saying, I would like to take what you own and develop it. I don't want to own it. I just want to take it and then ship it to somebody else who will own the end product at that point in time. So it's very much a contract-based interpretation, and it gets a little deceiving because it deals with real property, and we think it is a real property issue. But for most of us, especially those of us in Ohio, we've had to learn the hard way. This is a contract.
Right.
This is just contract law and what we're looking at here.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, Chris White, an attorney in rural Ohio, tears down Anadarko's standard oil and gas lease. It's a study in negotiating power, carefully defined terms, and really long sentences. Chris gives some hard-earned wisdom about protecting rural landowners who are too often powerless. So, let's tear it down. Hey everybody, welcome back to the Contract Teardown Show. I'm Mike Whalen. The purpose in this show is to take contracts and tear them down, to beat them up and say things we love and don't love, and hang out with smart friends like my friend Chris over here. Chris, how are you today, sir?
I'm doing well, Mike. Thanks.
Awesome. So guys, what we are talking about, let me share my screen with you real quick, is this document that can be found on Law Insider. We'll make sure that the link is included in the show notes. It's this paid-up oil and gas lease as between PCY Holdings and Anadarko. Is that right?
Anadarko.
Anadarko. And these two companies are entering this oil and gas lease. So, Chris, why? Why are we talking about this document? Why is it important to lawyers? When are they going to run into this thing?
This is oil and gas leasing and development is nationwide, and it's taken a hit here over the last couple of years, but it is constantly something that we need to keep an eye on for individual clients, corporate clients, whatever they are looking for. If they are owners of property or mineral rights exclusively, either one, that this is a potential for development because we're finding new holdings of and reserves of oil and gas across the country all over the place.
And what about you? What's your background? You're in Ohio, middle of nowhere. We're on internet that has a rat on a wheel in the background, making sure the
Absolutely.
the megabits keep moving. Tell me about your practice, Chris.
Let me feed the rat real quick. And there you go. We're good. And my practice is a general practice firm in northeastern Ohio. We serve about 26 counties from Franklin County, which is Columbus, all the way to the Ohio River. And we're about a 10-year-old firm. There's 18 of us. And right now, I am the chief of the tribe, running everybody from hither and yon over our network. I spent my time early on working with landowners and what we would call lessors in these leases, the owners of oil and gas mineral rights against national and multinational oil and gas companies that were coming in to develop the Appalachian Basin. And so since that time, we've expanded well beyond the energy law sector. We do a lot of things because we are a general practice. We have about 24 distinct practice areas that we focus on firm-wide. But our goal is to run a little bit different firm than our competitors, very client-centric, very goal-oriented in reaching and creating accessibility to justice and legal resolution and problem-solving across a wide market.
Rural practice. Everybody go read the book Lawyer Forward. It's all about how I broke my rural practice. Well, cool, Chris. What we're going to do then is I'm going to jump over to the document real quick, and we're going to go sort of through it point by point a bit. You've given me a highlighted range of things to talk about. So let's go through this thing. As a side note, I took on the bar exam, because I practiced in Texas, a section on oil and gas. But everything I know about oil and gas law, I learned from the Beverly Hillbillies. So we're going to contextualize this a little bit. Tell me a bit. I'm looking in the very early section about who the parties are, what exactly they're doing. Talk to me about this first paragraph that sort of lays out the context. Jed shoots outside. He's a poor mountaineer, barely kept his family fed. There's a rabbit, right? Was that what he was shooting at? So what's the context in this first paragraph for who the parties are and what's going on?
Yeah, absolutely. So traditional contract language which deceives you into thinking it is a contract about real property, it's a contract that involves real property. And so we interpret this under contract law. So you have a lessor, the person who controls the asset and interest, and a lessee, the person who is seeking to develop, extract, whatever it is. So traditional contract language, lessor, lessee structure. In this case, it was PCY Holdings and Anadarko, which we actually ran into Anadarko in Ohio. They were working on the fringes of some of the Appalachian Basin play, and we ran into them a little bit. And so Anadarko is approaching like anybody would a lessor, saying, I would like to take what you own and develop it. I don't want to own it. I just want to take it and then ship it to somebody else who will own the end product at that point in time. So it's very much a contract-based interpretation. And it gets a little deceiving because it deals with real property, and we think it is a real property issue. But for most of us, especially those of us in Ohio, we've had to learn the hard way. This is a contract.
Right.
This is just contract law and what we're looking at here.
Yeah, and it talks early about it's for the purpose of exploring for developing, producing, and marketing oil and gas, along with a bunch of broad terms that they're calling oil and gas substances. But it says that, this is the leased premises, and it covers accretions in any small strips or parcels of land. Now or hereafter. It starts to get really expansive. So in this first paragraph that's just setting sort of the background, do you like this language? Do you feel like this gets too broad for the sake of the lessor?
I think this is definitely a lessee drafted document. So they are the producer, and they are trying to be as expansive as possible in what they are giving themselves permission to take, which is not to be unexpected. In some of the more complex, deeper plays, because unlike Jed, who shot the ground and was able to puncture an oil and gas well right there, these are deep plays, and they have complex hydrocarbons that are involved with them. So it should not be unexpected that, yes, we're talking about oil, we're talking about gas, we're talking about natural gas liquids and hydrocarbons, of different sections. So that's not necessarily bad, but it is getting more and more expansive as the paragraph goes along. And you throw back to law school, this is basically a Mother Hubbard clause. This is basically saying, not only are you leasing to me what we're defining here, you're leasing to me anything else that's not defined here, any other adjacent properties that may be wrapped into this. And what they're doing is by contract, they're saying, not only are we getting what we've defined, we're getting anything else that might be available to us adjacent to what we've defined. And that's really, if you're talking about drafting for this, that's one of the most egregious parts of an oil and gas lease, is that you don't truly get a meeting of the minds, because the lessee, the producers, will often build in language that is expansive, that expands beyond what they're talking about in the moment, to say, well, if we find more, we can get more. And that's so unique to the oil and gas play. It's so unique to that. So that is one of my first problems with this lease, is it starts talking about things that you're like, okay, yeah, I can see why, but then it starts getting further and further afield from the specifics of what you've been talking about.
Right. Not only can we have this land, we can have any land that you imagine in the future that might exist. It's like a sci-fi play, really. Hey, everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. So I'm looking down at the ancillary rights, and as an aside, this reminds me of a plot line from the TV show Justified, which is awesome, and about this coal company and their operations. You look in ancillary rights, and they say, we got to be able to get in and out. We got to move equipment in and out. And a plot point in Justified was they couldn't get their coal in and out because they had to build a road. So talk to me about the reality in these rural communities where these oil stakes are happening of just getting in and out. Do you like this number 2, this section 2?
I don't. And here's why. Oil and gas leases are basically partnerships. You're entering into a partnership with this producer. But what you are doing in a paragraph like this is giving them a blank check. You're basically saying whatever you need to do and you deem necessary, you have the right to do. And that's a horrible partnership. You end up with developments on your property that may have gone beyond the scope of what you were contemplating when they thought, oh, we're going to come in and we're going to put down a Walmart parking lot sized pad on your property. And by the way, we're going to run telephone lines and power lines, and we're going to bury them through this area, and we're going to run pipelines off this direction. And as I've highlighted there in the 4th sentence, we're going to use off of this property the natural gas that's produced to run generators on this property. And what it doesn't call for in that is how that's going to be measured.
Right.
And so what are they blank check using on your property that you're not able to effectively monitor? And that is so key when you enter into any partnership, let alone an oil and gas lease, is how do you monitor your partner?
Right.
How do you monitor what's going on?
I'm thinking of number 3 here, the term of the lease. Moving on to that, they talk about the primary term being 3 years and any time after that, basically, in which there's any kind of oil and gas. Again, pretty expansive. This seems like you're getting into this for basically forever.
It is. And here's the problem. There is no place in here that gives the lessor any ability to interpret when this should end. This is completely at the lessee's discretion. In fact, in some Ohio leases, especially the older ones, you'll see this habendum clause that's so long thereafter as in the sole discretion of the lessee. And especially when you see language like that, you're abdicating control over the lifetime of this lease. You no longer have the ability to determine that. And if you actually drop down to number 4, I highlighted one of the undefined terms that are so key in leases, producing and paying quantities, because that is something that is an ill-defined term at law. Most places, because this is contract law, they do not have a defined what paying quantities is. And you're all the time fighting about this in court when there's a problem, because at the end of the day, they'll be like, it's in paying quantities, but we're not paying you because we're paying everything it takes to operate this well site on your property. And so the landowner's bearing the burden of having this production, having this operation on their property. And they're just basically, the oil and gas company is just operating it on the back of the landowner.
Forever.
And there's no benefit. Yeah, there's no benefit to them passing through.
Forever. That's a Sandlot reference.
Yep.
Speaking of number 4, these are some of the longest sentences I think I might have ever seen. It's talking about the operations and as basically what you were talking about, as long as they can be there. Talk to me about the sentences in this. I'm assuming you're feeling how I'm feeling about these absurdly long sentences.
When I cannot remember how the sentence started by the time I get to the end of it, and I have to create a sentence structure diagram just to figure out what's going on by the time, you are only opening up an area ripe for litigation. And here's who wins in litigation: the producer. The producer continues to operate the lease during, of course, of a litigation, unless you can somehow enjoin them. In which case, how is a landowner going to pay the bond to enjoin the production of an oil and gas operation, to shut it down? So the producer is going to continue to operate and continue to do this and delay tactic all the way through this, and then fight about these nuances that are, this sentence could be deconstructed and reconstructed 100 ways because it's so long. You've got to figure out how to do that. And, I'm not a grammarian. But I know when I read a sentence that is ambiguous at best.
Well, but tell me about, one of the things that we talked about in advance of having this chat is, most of our viewers are drafting. Would you, what's the argument for the drafter who is presumably representing the producer, right? What's the argument for them to keep these sentences legible? Does that help them avoid litigation as well? Would you lean towards clarity? I mean, I'm assuming they do this in part because they want to pull something over on the person who's the landowner, right? What is the argument for them to write this better?
The argument is not for them to write it better because, as I said at the very beginning, as the paragraph got more and more expansive about what they could do, the longer these sentences get, the more it gives them the flexibility to operate how in their own discretion. There's less oversight, less responsibility, and less accountability to their partner. Right. And so there is not, from a producer's standpoint, the interest to create concise, well-defined terms by which they can be held accountable to. And some of them might say, well, it's because we don't know what we're going to run into, which, okay, give credit where credit's due. You're drilling a mile underground, and in some ways 5 miles out horizontally. You won't know what you're going to run into. But that doesn't mean that you can't do better in the sense of giving the lessor something to stand on to understand how to keep their partner accountable in these scenarios. And these sentences are so long. They're just so long that you're just opening up a ripe area for confrontation, which litigation means that your client, who may not be getting paid what they were supposed to get paid in the first place, is now having to pay to keep their partner accountable and argue about the nuances of grammar simply because we didn't tighten it up enough.
Well, jumping down to 6, under the royalty payment, I see similarly long sentences. What are your feelings about the royalty payment section?
This section, actually, I have less complaint about this one. Now, this is not a great royalty clause in and of itself, but it very clearly states it's 20%. And then as you skip down to the second paragraph, of what is received by the lessee. It does actually state the reality of the situation very well. Here's what happens in very short. Drilling. Producer takes product from property, transfers it to third-party marketing, transportation, and sales company, who transfers it to end buyer. The money from end buyer passes back through third-party marketing and transportation and sales company, who take their cut. And then the net proceeds come back to the producer, and the landowner, lessor, is getting 20% of not the end product. They're getting 20% of the net. And so what is calling out here, and that is not explicitly said, and if you don't understand how the oil and gas industry works, it can very much think, well, barrel of oil was sold for $100 a barrel, and I'm supposed to get $20 of that. No, you're getting the net proceeds after the third-party marketing, transportation, and sales company has taken theirs. And this does at least a list that it can be an affiliate. This could be a third-party marketing and transportation and sales company who's owned by the mother company. And so the mother company owes the producer, owns the third-party company, and all the money's flowing in the same direction. They're getting theirs, but on the back of the landowner getting now 20% of, instead of $100, you're getting 20% of $70.
Or even, if the company is operating at a loss, or they're only making 3%, now you're getting 20% of 3%. They've got a lot of math that's different than you, average homeowner, that they can take a loss on particular properties or whatever, and it balances out in the, in their whole business, and you might be getting nothing again forever.
Yep. That is the bad royalty clause is where we are in the Appalachian Basin right now. We are in a place where we have operators who are operating oil and gas wells now for 6 months, and the landowners have not seen a dime. Yeah. They're basically paying the companies to sell the product off their property and not seeing any of the proceeds coming off of that due to the costs that the oil and gas company is lumping on top of that, and the way they've distributed that across other companies, so that at the end point, the lessee is getting such a fraction of what the value of the product is that there's almost nothing passing through to the landowner.
Well, jumping down to 11, there are a couple of sections here at the end about ending this thing. 11 is the release of the lease. Lessee may at any time and from time to time deliver to lessor or file of record a written release of this lease. What about this section is moving you?
Disturbing me as it should be. As you can tell, there is no agency given to the lessor. The lessor has no authority to end this lease and has no agency in this lease whatsoever. And that is, you get to the core of a drafter's job in an oil and gas lease. You need to establish as much agency as possible for your client, the lessor, because once that's done, they are at the complete mercy of the lessee's books, production, everything. They touch nothing between after that point in time the lease comes. They see a check that may has a royalty stub that they can't understand, and the lessee is taking everything at that point in time and has complete control over it. This lease does not give the lessor agency. They are simply a participant, which gets to the point of a legal issue of fiduciary duty, which in most states, because this is a contract and an arm's reach contract, they do not imply a fiduciary duty. So if there's no implied fiduciary duty, if there's no agency, your lessor is left in an ambiguous situation with no rights to check on their partner and only the ability to go sue, which when you get to paragraph 13, that's where it becomes a big problem too.
Yeah, I want to read this because 13 is about breach and default. This sentence, no litigation shall be initiated by lessor for damages, forfeiture, or cancellation with respect to any breach or default by lessee hereunder for a period of at least 60 days after lessor has given lessee written notice fully describing the breach or default, and then only if lessee fails to remedy the breach or default within such period. Gives a lot of power. Again.
Oh, yeah.
What are you thinking about this breach section?
This says this. It says, if you and I had a deal, Mike, and I find your hand in the till, and I slap your hand, and then you turn over the money that was belonging to me, I can't do anything about the fact that you're going to put your hand back in the till. I cannot hold you accountable to this. This is basically saying you're enabling bad acts until such time that you tell them they're acting badly, and they agree with you, and they pay you for that, and then the lease just continues to go. That is a toxic relationship.
Like, I'm reading this. If the matter is litigated and there is a final judgment determination that a breach or default has occurred, like we know there's been a breach, this lease shall not be forfeited or canceled in whole or in part unless lessee is given a reasonable time after the determination, again, to remedy. Like, they have this really great ability to keep the thing going on forever.
Absolutely. And it makes it accessible for them to transfer. It creates what I said earlier. It creates a transferable asset like it's real property, but under contract terms. And it creates this thing for this company to be a bad actor, even fail at its job, and then subsequently transfer it to somebody else because he can't cancel this. So you get in a string of decades of different producers who inherit the ability to keep you locked into this in perpetuity.
Well, before we close this thing up, what about 14? It's warranty. You know, warranties always come up, but especially because you do have this strange real estate overlap. What are you thinking about the warranty of title section?
This is not a bad section in this instance, but there are, as a drafter, needing to watch out for this. If you have a lessor who is giving an absolute warranty of title to the quality of their oil and gas interest under their property, you just stop right there, and you stop because that lease is now transferring the duty of responsibility on a real estate issue to a contractual clause that can create major problems for your owner. Not every state is going to struggle like this with Ohio, where you've got Rockefeller, who started in 1880 developing oil and gas, and you have subdivided oil and gas interests and royalty interests that go back now 130 years in history. Not every state has that same problem, but if your state has had multiple phases of oil and gas development, unless you're absolutely willing to put your client's neck on the line to say that it's good because they have 100% fee simple interest in this, don't warrant. Do not warrant this interest. Let the producer satisfy themselves that you have the interest, and they take responsibility for that. So that's the note on that. This clause in itself is not horrible, but that is the thing to watch out for.
Something to watch out for, yeah. And as we close, I'm thinking about general principles, right? Some of it that applies to oil and gas leases more generally, and you pointed to some of that, but also the principle that might relate to drafting in general. And I'm thinking about the power relationship in a transaction. You know, that leverage is always so important about who's drafting and who's not, right? Who's right. Like what you have to sign off on and just agree to, and what you have the flexibility to draft in. Is there a principle to draw from this in terms of you, as the little guy, your power to redraft a document like this?
And that is the point. You like put your finger right on it. this PCY, they actually have a significant amount of acreage, which gives them some leverage when it comes to negotiating with an oil and gas company. The smaller amount of acreage you have, the less leverage you have, because they're after a product which is determined by an acreage size. If you have less acres, it becomes increasingly more difficult to negotiate for changes in language and greater agency than if you have 1,280 acres, and you can kind of swing the stick around a little bit. The general principle, that being aside, that's a negotiating just reality of oil and gas leases. That being aside, the best principles to take from this is instill as much agency as possible in your client, the ability to check up, to know what's going on, to have the ability to exercise their rights inside of this, and then keep the terms as concise as possible. Don't let them ramble on for a paragraph in one sentence and then say, oh, well, that'll never become an issue, because that will be the exact place they will hedge their argument that things are okay.
If a sentence has a subclause 7D, you're in trouble. So I think the lesson here is that Beverly Hillbillies is fiction.
Yep.
Don't watch that. It's not a documentary. But it can be marvelous. Chris, if people want to get in touch with you to talk more about these kinds of things and your practice, and it's really innovative and interesting, if somebody wants to reach out to you, what's the best way to get a hold of you?
You can get me on my email, which is my initial cmw@thewhitelawoffice.com. I'm on Twitter at J, the number 38 spelled out. And I think I'm on Facebook too, someplace. And so you can just catch up with me wherever it's best for you to find me.
Stalk Chris wherever you have to. Guys, if you want information on this contract, this document, and on any of the stuff that we talked about in this episode, just go to the show notes for this episode. They're at lawinsider.com/resources. And if you want to be a super nerd hanging out with me like Chris on the Contract Teardown Show, just reach out to us. We're at community@lawinsider.com. And we will see you guys next time. Thanks, Chris.
Thanks.